Hi all. So welcome to the business law session. Today the concern is all about consideration. So we discussed only matters related to the agreements and contracts. We discussed about the acceptance and offer. Now here today we are going to discuss about the consideration. Right. First let's look at the lesson outcomes. Through this lesson we are going to define and discuss about the considerations in agreements or the business contracts, as well as to get to know about the essentials or the basic things to be considered in making consideration for a valid consideration, as well as to discuss about the circumstance exemptions. Like there are some sort of, when it comes to a basic business contract, there's a compulsory requirement. Let's say it's a requirement to have a consideration on that sort of a contract, but there are some sort of exemptions as well. Even without a consideration we can come into a contract, right? So which means we can form an agreement, right? Then the next one is understanding the privity of the contract rule. There's a thing called privity of contract, so we are going to discuss it today, as well as to get to know about some sort of important information about the considerations. All right, so we'll move to the first slide to get to know about the definition of the consideration. Now, consideration can simply be defined as a price for which the promise of the other is bought. Now, obviously, when it comes to an agreement, let's say the promisor and the promise is there, right? So the promisor is giving the promise to the promisee, where the promisee is accepting it on a consideration. That's generally a monetary value, right? Now, those considerations are happening subject to a sort of conditions. Let's say this can be defined as a price for which the promise of the other party is bought, right? The other party's promise. Like, as an example, let's say a tenancy contract. Let's say you and me are there, and I'm the promisor and you are the promisee, where I'm going to give you the offer, or let's say I'm the offeror and you are the offeree, right? In that particular contract, I will offer you by saying this particular building will be rented to you at a cost of, let's say, an X amount, right? You will accept it without counter-offering on that particular offer. You will accept that offer saying that I will accept the terms and conditions of this contract, which means that you agree to pay that particular sum to me as the benefit of having that particular tenancy, or let's say that particular property to your whatever the business purpose, let's say. So in that case, the amount that you considered or the amount that you have agreed with me as the rent is taken into the consideration as the consideration. That is the amount that you have agreed with me to pay me as in case of the facilitation of that particular tenancy facility, right? So in a way, the consideration is a payment of money, and it's a vital element in law of contracts. Now, without consideration, it cannot be considered as a valid contract in most cases. I'm telling most cases because there are some of the exemptionable cases as well, right? But in the most cases, we consider the consideration as a as a compulsory element for business agreements and contracts, right? Consideration is almost a benefit which must be bargained for between the parties. Let's say, as an example, this consideration can be bargained. Now, as an example, let's say if you are not agreeing with the tenancy amount, whatever I'm going to get from you, like whatever I'm going to receive from you as the rent, so you can negotiate it on it, right? And is the essential reason for parting, engaging, or entering into the contract. That is why, based on the consideration only, we are going to the particular contract, right? Okay, fine. Hope you understood it well, right? There are types of considerations. When it comes to types of consideration, there are varieties. The first one is a promise to do something. Now, let's look at our example. I will give you my property as because of you are paying me a sum of money, right? So I promise to do something, and in return you promise to do something to me as well, right? The consideration has formed in my end, but I just gave it to you as the offer, so you accepted it, right? So in that case, you promise to pay that sum to me, which means that you promise to do something, right? Then the second one is a promise to not to do something. As an example, there can be, right? So if somebody asks you to not to do that particular act on some sort of a money value, right? I will pay you this much, don't do it. So simply, if you have accepted it, in the sense, since you are getting that sort of a benefit, you will say, okay, I will not do that. So a promise not to do something is also a part of a consideration. It's a way of a consideration. Then doing something, conducting something is also a part of a consideration. It's a way of a consideration. And refraining from doing something, a benefit flowing to the promiser. Now, as an example, if I am the offeror, you are the offeree, I offer something to you, and in return you will pay me a rent income. So that will received by myself. So that is what we call as a benefit flowing to the promiser, flowing from the promisee, right? That is an agent. And a benefit flowing to third party at the direction of the promisor. If I tell that assume that I'm having a creditor, right? So not like, rather I'm getting that amount from you, I will ask you to directly remit that amount to that particular creditor to pay off my debts. So that is one way of, appointing somebody, let's say a third person or a third party, as the receiver of something, receiver of a consideration. So your consideration will be received by a third party or a named person by the promisor, right? And the next one is a detriment to the promisee, right? It's a cost for you, to the promisee, right? So moving to the next session, slide, you can see essentials of a valid consideration. So what are the things to be considered to become a valid consideration? Consideration must move at the desire of the promisor. As I told you earlier, that has to be come from the promisor itself. The offer, whenever the person is making the offer, so that particular consideration has to be given by the promisor to the promisee. Promisee just do the acceptance of that. And also that will be a detriment to the promisee, which will be received by the promisor. Right? Fine. See the points. The promise must be done at the desire or the request of the promisor. Acts done or services rendered any voluntarily or at the desire of the third party will not amount to a valid consideration. Right? And doesn't require that the consideration must confer some benefit to the promisor. It would be enough act of forbearance or promise constituting the consideration was done or given the promisor's request, the benefit may accrue to a third party. You must remember all these conditions whenever you are considering it as a valid consideration. So let's move to the next slide. Essential of a valid consideration. Now, when it comes to the second point, consideration may move from the promisee or any other person. That has to be moved towards the promisor, but it should move from the promisee. Now, in that case, it is immaterial who furnished it. Anyway, that has to be moved from the promisee to the promisor. Right. So, and also it's must to know that strangers cannot sue over the contracts. Stranger, if a person is stranger to a contract, he or she cannot sue the other party. Right. So, doctrine of constructive consideration is also there. We discussed about the contracts and agreements where people signed those are like cumulative contracts, right? Two or more parties became to a contract with one party, or it can be two or three parties have accepted something from a promise, or a single promise, or something. When it comes to doctrine of constructive consideration, it's like even a stranger to consideration can sue. Now, can you understand? In previous case, we told like the strangers cannot sue over the contracts. But if a person can prove that he's a related party, or he or she is a party to the contract, then of course even a stranger can sue. Right. There are some few exemptions when it comes to this constructive considerations or doctrine of constructive considerations. The first one is expressed or implied trust. Now, as an example, let's say there are three people known as A and B and C. A is having a commodity where A is transferring all these commodities to C based on the trust, right? Where C doesn't have any title of the goods, but just because of A's trust, A has transferred the goods to C. In that case, let's say even the A is not there, saying that B is an interested party for this contract. Let's say A has to sell this commodity to B, right? But before selling those commodities to the B, A is sending those commodities C. Now C doesn't have any title of the good, but still B had the contract with A to receive that particular goods. Because of that, B can sue over C, right? Even B is a stranger, but still he can sue over the damages, right? Family settlements, of course, if you can prove that you are a related party, you can sue over the cases. When the defendant constitutes him or herself as the agent of a third party, that is the next circumstance. Let's say defendant constitute, when a defendant furnish a sufficient evidence to prove that he or she is an agent of a, let's say, of a third party, right? In that case also it is exempted, that the person can sue over the case. And also in the case of agency, especially you are signing the agreements with your companies, right? It doesn't matter whether the consideration is there, you can sue, right? And in case of assignment of rights under the contracts, let's say if the person is insane, those who have come into an agreement, one party is insane, on behalf of him or her, you can appoint the legal personality, or let's say the attorney of that particular person. So under that, the contract responsibilities and terms will be transferred to that particular attorney. So in that case, the rights will also come into that coming under that attorney. So because of that, the stranger can sue over the case. Then let's move to the next slide. That is, consideration may be past, present, or future. Consideration can either be past, present, or future. Doesn't matter. But when it comes to business agreements, our advice is to go with present or future considerations, right? Past is the past, right? If somebody expected something and done something to you, in the sense it may become a sort of a past consideration. But for the safe side, we expect you to go with present or the future considerations, right? Okay. So past consideration is which is already executed. Let's say if somebody has done something to you, let's say a help, right? Like let's say in an event where you didn't have the money, somebody has provided you with a sum of rupees, right? It's a monetary value, and on your request or on your urgency, somebody has provided it to you. With this, you can also make a contract in future, right? So which the deal, I mean the transactions which we have discussed, which can be considered as the past consideration. So where it's not safe to you to have the past considerations, because there can be so many circumstances where you cannot, like where you will be unable to get the justice over the case. So because of that, we are not recommending those types of past considerations. When it comes to the present consideration, where you are simultaneously agreeing with somebody, or let's say the consideration which simultaneously happening with the promise. Just because of the promise, you will give something in return. If you are the promisee, you will give something in return. That is called the present case, the present consideration. Future consideration, which is an executory consideration, which is to be done in future time, right? Let's say it's like this. When the consideration on both sides is to move at the future date, right? This act has to be done by yourself, which I will pay this much of sums to you. That is a future consideration, right? Which are very precise and which are very safe side, right? And consideration is also, it has to be invalid. Remember that, right? And consideration must be real, in the sense you can, you should be having, you can see the consideration. Can be in a monetary value, in the sense nowadays it can be in e-money, right? Electric medium, but still you can see the value, right? Fine. Then moving to the exemption rule. I told you in the beginning of this session, I told you about if there's no consideration, there cannot be some of the contracts. There cannot be agreements, right? But there's an exemption where even without a consideration, there can be the agreements or the contracts exists. So let's see how. Agreement made on account of natural love and affection. For the love and affection, you don't want any considerations, right? If you want, you can experience it and see, right? For the love and affection, you don't want anything, right? For your mother's love, for your father's love, you don't want any considerations to be, assured your love and affection agreement, right? Then agreement to compensate for the past voluntary services. Agreement to compensate for past voluntary service. Now, as an example, let's say the first case is must be a service rendered by the promiser voluntarily, right? Well, let's say for the past service rendered by you from somebody doesn't want any sort of a consideration to prove. In that sense, you made an agreement already, right? Now, whichever the service is rendered, the service provider is having the right to claim over the, let's say, it can be the amount that due in with his service, right? For the amount that he has provided you the service, let's say that is the service charge, you are liable to pay that service charge to him because he has already provided the service, right? So in that case, we consider some of the conditions. Must be service rendered by the promisor voluntarily, right? Must be a service rendered by the promisor. Even if I have requested somebody to give me the service, then it's done, right? Promisor must be in the existence at the time. Now, if you were there in person, if you were there at the time where he was providing you the service, so you are liable to pay for that particular service. But you must be in person in that circumstance, right? Promisor must compensate the person who has done something for him. So you are having that liability, right? You must pay something to that person. The intention of the promisor ought to be compensate the promisee, right? Your intention. Then the promisor to whom the service has been rendered need not to be competent to contract at the time the service was rendered. Read it carefully. The promisor to whom the service has been rendered need not to be competent to contract at the time the service was rendered, right? Service has rendered in the sense you made an agreement, in the sense that is the case. You don't want to worry about signing agreements and things like that, but you accepted that particular service rendering a service, in the sense you are expecting a service, somebody has provided the service, so you accepted it, in the sense it's accepted. contract is made. The service rendered must be legal. It has to be a legal service. I told you, there are illegal circumstances where if you are having included an illegal contract in your in illegal terms in your even the conditions in your contract, so it may become a voidable contract, right? So be careful. The act or the service rendered must be legal. So these are the exemptions, and where the agreements to pay time-bound debt is considered as an exemption for this no consideration, no contract rule. And completed gift. If somebody has given you a gift, you have accepted it in the sense it's a past case, but still the possession is with you. So because of that, there should not be a consideration for the contract because you have already accepted that offer, right? So even though there's no any consideration, but still it's an agreement, right? Contract of agency. Yeah, your contract of agency in the sense your employment opportunity is the employment contract. It is a contract of agency, right? You don't want any consideration to make valid contracts. And remission of the promisee of performance of the promisor. Contribution to a charity. All these things doesn't need any consideration to build up a contract, right? So we'll move. Then finally, we are going to the privity of contract rule. What do you mean by privity of contract? See the definition. The doctrine of the privity of contract is a common law principle which provides that a contract cannot confer rights or impose obligations upon any person who is a party to the contract. The promisee is that only parties to contracts should be able to sue or to enforce their rights or claim the damages as such. Read it carefully. The doctrine of privity of the contract is a common law principle. It's a common law principle which provides that a contract cannot confer the rights or impose obligations, right, upon any person who is not a party to the contract. Now, even if there's a person who's not a party of that particular contract, you can confer or you can obligate that person to the contract, right? So the promisee is that the only person to contract should be able to sue or to enforce. I told you about the demands and things, right? The promisee can enforce the promisor through demanding to do the promise, right? So in that case, parties to the contract should be able to sue or to enforce over the promisor. So these are the things where we should have to consider in consideration. And let's see in the next week, we are expecting to discuss about offer and acceptance, and here the consideration. And in the next time, we are going to consider about the warranties and conditions of contracts. So thank you very much for listening to this lecture. Thank you.